the digital use of music, which includes downloading, sort of where the end user ends up with a copy, and streaming, where the end user just hears the song but does not make a permanent copy, implicate a whole set of issues in copyright law which are very, very complex. First, let me say, we've been talking just about the music composition, but it's important to point out that a sound recording of a music composition or of anything else under copyright law is a separate, distinct, copyrightable work. So for example, if I go to the beach and I make a sound recording of the waves crashing on the shore, I have a copyright in my sound recording. That is an independent copyrightable work. The same thing is if I make a sound recording of a musician performing a composition in a studio. The composer has a copyright in the original musical composition, but the recording engineer has a copyright in the sound recording. That's a separate, independent, copyrightable work. Now, when someone records for a label, usually this is all worked out by contract, and the label will own the copyright in the sound recording, and usually it's the composer that retains the copyright in the musical composition. But again, at least by law, these are two separate, distinct works. And the mechanical license, right, whereas if someone can make a cover recording of a previously recorded song, only is a compulsory license for the musical composition. Someone who wants to make an exact copy of a sound recording still has to get permission of the owner of the copyright in the sound recording. So in the digital arena, if I want to set up a website, let's say, and I want to download sound recordings, I've got to get permission from the owner of the copyright in the sound recordings in order to do that. Under the Copyright Act, I do not have to get permission from the owner of the rights in the musical composition, because that falls within the compulsory license for mechanicals. Right? It's considered to be a digital phonorecord delivery, which falls within the ambit of the cover recording exception. If I'm webcasting, if I'm streaming sound recordings over the internet, there's a whole other series of very complicated provisions of the Copyright Act that apply. That may or may not fall within a statutory license for the sound recording. Depends on the nature of my webcasting. With respect to the musical composition, I will have to get permission, but those rights are generally administered by ASCAP or BMI or another collective licensing society.